Our panel this evening, in reverse order of how they showed up tonight, lead off with our gentle giant, Hugh Willis from Willis Law. Our dapperly dressed Roberto Noche from Miller Thompson. And our likely contrarian this evening, Todd Shipley from Reynolds, Mirth, Richards and Farmer. I'm going to turn the microphone over to Mr. Willis, who will get us started on our first slide.
Hello, can everybody hear that? All right. So, just my initial comment before we start is, when we did this before, there was a lot of concern about what was included in the proposed regulations, and we discussed that. People gave us feedback. That was carried forward. There's as much discussion today about what was removed as what is new or what is different from this time last year. And I think, just from my perspective, a lot of credit goes to the current minister for listening and hearing what people who attended these sorts of sessions were saying about some of the head scratchers that we had before. All right, all that said, let's jump into this. So, we got our first slide there. We broke this into 3 stages. The first stage we saw a couple years ago, which was essentially our developer regulations. The items that were the last, 2019 were our governance issues, how we make decisions, insurance, basically the bulk of what we're talking to tonight about, and this is really what affects existing condo corporations. That was to have come into force, of course, July 1st of 2019. The government threw the anchor on that, did some additional consultation. Late November it was announced and took effect as of January 1st. There's a few items that were still on governance issues in stage 2 that we're going to be talking about. There's going to be some additional consultations next week, being voting and chargebacks that CCI is invited to. And then the future stage, I guess, that we're still looking for, we're still pressing for, hoping to see is condominium licensing, as well as the Condominium Dispute Tribunal, which will be both, require a fair bit of input and work to make sure we try and get that right. So, the legislation has seen a major overhaul. We've seen massive regulatory change. What do we do with our bylaws? In my opinion, quite frankly, if you haven't started a bylaw process, now's the time to do it, and to review your bylaws or have a new set done. In the legislation, or one of the challenges we have with bylaws is we need 75% of the owners and 7,500 unit factors to pass the bylaw change, what's called a special resolution. One of the changes, or one of the transitional provisions, as they call it in the regulations, is that bylaws can be passed for 1 year under ordinary resolution, being a majority to properly called meeting. Well, isn't this great? Isn't this exciting? We need to put sirens and warning about this. It's not an ordinary resolution for every bylaw. In fact, it's very narrow. If all you are doing is making a change so that your bylaws now comply with the change in legislation, you can do that by ordinary resolution. Everything else still requires a special resolution. You jump to the next slide. So, sure. Everything that isn't in conflict, or where your bylaws were silent, or where it's new, will still require the special resolution. This, quite frankly, in all of the changes, this ordinary resolution provision is the one that causes me the most concern. So here's an example of where a bylaw would be appropriate for an ordinary resolution. If your bylaws say we can issue a fine up to $2,000. Now the regulations say first offense is $500, second offense is $1,000. If all you are doing is changing those numbers, that would be appropriate by an ordinary resolution. If your amount of the rental deposit had amounts that were different than what the regulations now permit, that would be appropriate by ordinary resolution. However, if your bylaws were silent and they never contemplated cannabis, or if your insurance bylaw, you're going to change that to make it more in line with what the legislation is on how we collect deductibles, that's not addressing a conflict. That is a change. And most corporations, we're not changing bylaws every year. We're lucky to get it every 7 or 10 years. How many people here have bylaws that are more than 15 years old? Right? When you go to enforce your bylaws, before you issue a sanction, one of the things you have to do is prove that they were properly passed. And my fear is that we're going to see corporations who try to sneak something in through ordinary resolution, and for the next 20 years, every time you go to enforce, the first question is, prove you passed it properly. You can't? Sorry. I get away, right? So I want, this is a provision in here. I think you're going to hear a lot of chatter in the industry about that. But this is one that is a tool available if all we're doing is a slight tweak to a few bylaws. But if we're doing anything more than that, we still need to do the specials, the special resolutions. Okay, next slide. Those people who are on the appendix bylaws, the default bylaws at the back of the legislation, those have been updated as well. So the government has changed Appendix 1 and Appendix 2. They're now, instead of at the back of the Act, they're going to be in the regulations. And it's Appendix 3 and Appendix 4, depending on the year your condo was registered. So by design, the legislation is your basic framework, and the intent for the past 40 years or so has been your bylaws fill in the meat to the regulatory skeleton. The appendix bylaws are still not pretty, they're very basic. Remember, those will apply whether it's a shopping mall, whether it's your condo is an apartment style, lake lots, townhouse style. That default set is something that you should be working to, quite frankly, update and customize for your particular circumstance. Okay, so that's our section on bylaws. Now we're talking about rules. So whereas bylaws are something that the owners put into their contract, their bylaws, and 75% of the owners and 7,500 of the unit factors agree, there's confirmed in here a process regarding rules. And what we do with rules is these are decisions made by the board, or provisions put in by the board. Rules are there, they can be very good things, and they're there to address the procedures we're using within the corporation. So here's how we can book the social room. Here's the rules around the amenities room. Here's the rule around the pools. It can address the property of the corporation, the common property, the managed property. Note, the rules may not restrict how you use your unit, how you use your home. So even in a bare land scenario, how many people here are bare land? Do we know? So if you're bare land, you want to make sure if you intend to have something where you want the board to be able to put rules in place, make sure your managed property definitions are fine-tuned with that as well. In my opinion, rules that are there to address efficiency, address process are appropriate. Rules that are there to try and shortcut the bylaw process, where you're trying to take away someone's ability to use their homes or use their units, I don't think are appropriate. I know Robert, there's the case I always look to is one of Robert's. I went to the Court of Appeal on that. But now we have legislative authority and legislative process around those. So rules can be really good, but let's make sure that we're not trying through a rule to do something that should be in a bylaw. Go to the next slide. So when we do rules, we have to give written notice to both the owners and the tenants. Okay, so as part of the discussion, it's like, well, condo corporations were trying to get away from the corporation being obligated to deal directly with the tenant. It should be the landlord's responsibility. However, on this part, the idea is that the rule is something that the corporation has to serve on both the owner and the tenant. If you had rules before, and when we say rules, that could be something described as policies, it could be described as a regulation, whatever term or title you want to put on it. If you had them in effect before January 1st, 2020, you need to have a board resolution to reenact them. You have to do that before the end of March. If you don't, those previous rules are no longer in effect. Okay, they're wiped out. They expire. Sorry? Sure. So if you had previous rules, the new regulations say that you have until end of March, to renew them. So to pass them again and record that in your minutes at the board level, and serve copies on all the owners. It's probably a good idea to review your rules to see if they're still, if you've had the same rules in place for 15 years, see if they're still appropriate. Do they need to be tweaked? Take the opportunity. Rules do not come into effect until after 30 days after everyone has been served. So the service part, when Robert's going to get into that in a few slides, is really important, because if we miss one owner, we don't get to start the clock ticking of when these rules kick in. Now, there is an exception in the case of emergencies, where the board can pass rules clearly defined in your board minutes, and they can take effect immediately. It's for an emergency, and the bylaw, or that rule, expires when that emergency no longer occurs. So what's a great example? We're replacing all the railings on our balconies. The rule is don't use your balcony. Sadly, believe it or not, we've had to go to court twice on that. So that would be an appropriate rule. That emergency rule could take effect immediately, and it would expire after the balconies are back on. Okay. Next slide. So how we can notify a new rule is you can deliver it to the unit. So that's how you would take care of the tenants and the on-site owners. Or you can post it in an open and conspicuous common area space. What does that mean? Well, I think for most people, it would, the first thing that comes to mind is a bulletin board on site. But the way that's drafted, could we tape it to a bunch of posts? Would that, potentially you could. Whether or not you should is a different. The idea with the rule is you want people to understand what's expected, so they're more likely to meet that expectation. And the more we, if we're just walking around and put it under each door, that might be easier. And then you have to serve written notice to all owners who do not reside on the parcel. And again, Robert will talk about that in a moment. If owners don't like the rule, the owners have the ability to replace the rule or rescind the rule, change it, or stop it by ordinary resolution. So one of the questions we have is if an owner says, I don't like this rule, it doesn't make sense, I want to take this to the owners to vote, please put this on the agenda at the AGM. So my question for you is that an appropriate item to have as new business on your AGM agenda if an owner requests that? How many people would say yes?
Well, it was until they changed the regulations. Now I'm waiting for an answer.
You're right. The answer is this one is yes. If an owner writes on that, and because this is something that affects the whole corporation, it's a specific process allowed in the legislation. It would be appropriate if an owner requests to have a rule reconsidered, that it goes on the AGM agenda if so requested. Other things about rules, you can't do monetary sanctions, so fines, for violations of rules, only for violations of bylaws, which again, you want to be certain items, if they're hot button items in your particular complex, you may want to make sure those are in your bylaw rewrite. So what's an example of a non-monetary sanction? I know enough of you I can start pointing. Best example of a non-monetary sanction would be you left the social room a mess, you don't get to use it for 60 days. Things like that, okay? Yeah, there's a few other examples, but we'll leave it for that right now. If a rule is inconsistent or contradicts the bylaws prevail. And of course, if a bylaw contradicts the act prevails as well. So we talked last year about starting to put together a rules manual. How many people have actually started doing that? Oh, a few. Good for you. Good, okay, good work. Keep going. Again, with rules, when we get into the documents that owners can request, so minutes, bylaws, reserve fund study, a copy of all rules is now another document or item that an owner can request. So to make all your lives easier, start compiling that into a manual right now, and that way you're not sort of hodgepodging in a rush trying to catch it together once an owner requests it. That's rules.